Hi, Kathy Bracken here to talk to you about a case that's in front of the United States Supreme Court right now, and it's a Social Security case. It involves the issue of posthumously conceived children. So that is children who are conceived after a parent's death, and whether those children are entitled to Social Security survivors benefits. So this is what happened. There was a couple, Mr. and Mrs. Capato, and shortly after they were married, they learned that Mr. Capato had cancer. So before he started his chemotherapy, he decided to deposit his sperm at a fertility clinic for future use. And later on, they did, in fact, have a son. Unfortunately, Mr. Capato passed away, and after his death, his wife wanted to have another child, so she used the sperm, became pregnant through in vitro fertilization, and gave birth to twins. She applied for Social Security survivor benefits for the children and was denied. So the case worked its way all the way up to the Supreme Court, and what the court is struggling with is the definition of who is the child, quote unquote, of a wage earner for purposes of the Social Security Act. So the Supreme Court heard oral arguments last week, and now we're just waiting for the decision. So this is a clash of a federal law that was written in 1939 and modern reproductive technologies. My opinion is that the benefits should not be granted. The purpose of survivor benefits is to replace the income of a deceased parent for a child who was dependent on that parent's income. So if you want to do in vitro fertilization with the sperm of a deceased person, you are on your own, in my opinion. So let me know what you think. I'll keep you posted on the decision. I'm Kathy Bracken.